All right, give me 1 second, Carl. Get the stream going. Okay, Carl, when you're ready.
Good. Thank you, and good evening, everyone. Welcome to the Hillsborough Township Planning Board public meeting of February 25th, 2021, which is being conducted virtually. All board members, staff, and consultants will be participating remotely. The public will be given an opportunity to participate remotely through the advertised Zoom link or optional phone number identified in the public meeting notice. Members of the public should use the raise hand feature in Zoom. It's that little icon, or press *9 if participating by telephone to indicate that you would like to be recognized to speak. Meeting and application documents have been made available through the township's website in accordance with the public meeting notice. Applicants will be presenting remotely and will identify themselves before testifying. So with that, please join me in a salute to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be advised this meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, otherwise known as the Sunshine Law. Notice of the 2021 annual meeting schedule has been provided to the officially designated newspapers, the township clerk, and also posted on the bulletin board at the Hillsborough Township Municipal Complex and posted to the township's website. Additional notice has been provided to communicate that this meeting is being conducted according to the governor's executive orders and pursuant to Public Law 2020, C-11, which allows for meetings to be conducted electronically and pursuant to the local finance notices recently established in the state of New Jersey. With that, may I have a roll call, please?
Mr. Wagner and Mr. Scoble are absent. Mr. Emick?
Emick here.
Mr. Ciccarelli?
Emick here.
Here.
Mr. Peason?
Yes, here.
Mr. Santa Ramita? Mr. Hastag?
Here.
Deputy Mayor Delcor?
Here.
Mayor Lapani?
Here.
Vice Chair Julian?
Here.
Chair Sirachi?
Here.
And Mr. Kinsler?
I'm here.
Mr. Maskey?
Here.
Mr. Euro?
Here.
And Mr. Bernstein?
Here.
Okay, perfect. Thank you. And again, welcome everybody. Not much on this evening's agenda. We do not have any consideration of meeting minutes nor resolutions. And there's no planning board business other than the one application. But before we go there, I will open it up to business from the floor, which is for matters that are not on the agenda. So if there's anything that you would like to address this board, please either raise your hand if you're participating through Zoom or press *9 if you're dialing in by phone. And I don't believe I see anybody.
We have one.
I just saw, yep.
All right, again, please state your name and address for the record, spelling your last name, please. You're a phone caller, so you'll need to press *6 to unmute yourself. There you go. State your name and address for the record, please, and spelling your last name.
Yes, hi, it's Maria Janusic, Janucik, 720 East Freck Avenue, Manville, New Jersey. And I'm also a Hillsborough Township property owner, Block 86, Lot 3, 2155, Camp Lane Road. This is in regard to the records that have been provided for the public viewing on the website with the planning board application. I sent an email to Mr. Maskey, but it was late, so I don't know if he saw it or not. But there are records that are very vital to this application that are not provided. One of them is that settlement of litigation agreement, because that's the document that shows how this application can be allowed to come before the planning board, because block 58 lot 1.05 is in an I3 light industrial zone, which doesn't permit residential housing. So the excuse me, settlement of litigation agreement is what gives authority to have this application heard, and then also the ordinance 2019-20, and that is shown on that list. But then the ordinance has to be filed with the Somerset County Planning Board. So there needs to be a record that it was filed, and there is no record of that. Also, there is a conservation and wetlands easement on this property, which also isn't shown. And I received a copy of that conservation and wetlands easement through an Oprah request, and that document shows that it was prepared by Thomas C. Miller, Esquire, and it's dated November 18, 1999. Thomas C. Miller is now the Superior Court judge who is giving approval of all of this. And since Robert Weiss, Campus Associates LLC, had previously been a client, and also it was in regard to this same property, I believe that Judge Miller should have recused himself, since it would be a conflict of interest.
Mr. Bernstein, would you like to address?
Well, I believe as to item number 2, the issue of the notice of the Somerset County Planning Board on the ordinance, and Mr. Maskey can correct me, Mrs. Janasek was provided, in fact, with a copy of the notice, which was submitted to the planning board over a year ago, I believe, sometime in the fall of 2019. I don't have the date in front of me. David, you can correct me.
No, that's correct.
Okay.
Well, Mr. Attorney Bernstein, I submitted an Oprah request last month for the record showing that Hillsborough Township Ordinance 2019-20 was recorded with the Somerset County Planning Board, and I asked for the date of filing. What I was provided with was a form that gave the number of the ordinance, but it had no information that was required, which at the bottom of the form says if there's anything missing to contact the representative, and there was no signature of anyone, so that it was a useless piece of paper basically, and that's what I received both from Pamela Borek, the registered municipal clerk of Hillsborough, and what I received from Mr. Maskey. So that is not any kind of government record, because it has
I'm sorry, that is the document that is provided to us by the county planning board.
Mr. Chairman, these comments do relate to this application. I thought that you were looking for comments from the public.
Well, I'm gonna make this very quick, Mr. Policastro.
Yeah, I'd like to be heard if you don't nail it. I appreciate that.
Item 2 has been taken care of. Item 1, as to the litigation settlement, is not germane to the application in and of itself. The ordinance that's part of it is germane. The governing body, the board, is aware of the situation and therefore is not of issue here. As for the issue that you raised late this afternoon as to the possibility that Judge Miller may or may not have been involved in some kind of transaction involving Mr. Policastro's client over 20 years ago, this board is not within the jurisdiction to hear that situation. There are other avenues available, and it is not an issue before this board. And with that, Mr. Chairman, I think there's no further need to have a discussion on this issue.
Thank you.
Okay, you commented that some kind of issue regarding Thomas C. Miller and Robert Weiss. This is a conservation and wetlands easement for this property. This was brought up by David Maskey, the Hillsborough Township planner, during the December 3rd, 2020 meeting, that there was an easement, but it was never provided, and Mr. Maskey was going to look into it. And so I opened it, and this is important, and it is germane to this application, as is the settlement of litigation agreement, because that needs to be authorized and approved by the judge before anything can go further with this application. So both of them are very germane to this application. And Attorney Policastro, I sent him a letter requesting that information, the recording of Hillsborough Township Ordinance 2019-20. I requested that information. I received no response from him.
Mr. Chairman, I've rendered my opinion on same. I don't think there needs to be any further discussion from the board. I would suggest that the board move on.
Yeah,
To hear this application.
Mr. Chairman, can I just add one comment so that I know we have a number of people from the public that are looking to participate in the meeting tonight. I would please that we have a process that we're supposed to go through. I would ask that you recognize when the chairman indicates what you're able to comment about, that we make sure we're following that, because we do need to follow a quasi-judicial process here. So when it's about matters not on the agenda, that's what we should be talking about. When it's about testimony, that's what you should be asking questions about. It's not a free-for-all to ask whatever you want, whenever you want. So I'd ask, please respect the process, and the chairman will direct you as to the point of what is eligible to be commented on. At the end, we will have a full session that you can comment before there's a vote. But recognize how we're going to go about this.
I understand that.
That wasn't directed to you, Ms. Janasek. That was a public comment.
Okay, but I'm the person asking the question, and I'm responding to some of the answers.
But you're already out.
You're also not.
None of the witnesses.
Mr. Chairman, I would ask that the witness.
Mr. Kinsler.
None of the witnesses talk about the
Mr.
easement.
Kinsler.
Mr. Chairman, I would ask that the individual be
Right.
declared out of order, and we
Yeah.
can move on with the agenda, please.
Chairman, I have muted the
Right.
caller.
Right, and just to remind everyone on the public, and I know it gets said on some other bodies, particularly school board, I know this was, for business from the floor, commenting on items that are not on the agenda, not a Q&A session. So I just want to remind everyone of that. Is there anyone else from the public that would wish to provide comment to the board on items not on this agenda? All right.
I see none, Chairman.
Okay, I do see Beth McManus out there.
Yes. Would you like me to promote her?
Yes, let's promote her.
Okay. Hello, Miss McManus. Can you just let us know you're there when you could unmute yourself?
Nope. Hi, folks.
Great, thank you.
All right. And I also see Mr. Weiss. Ms. Castro, would you like him to be promoted?
Sure. Thank you.
Okay.
Mr. Weiss has been promoted. If you could just let us know you can hear us and we can hear you, Mr. Weiss.
Sure. Thank you. I hear
Great.
you.
All right.
Thank you.
Perfect.
I just love the word promoted,
That comes with no extra pay.
clearly.
Limited time.
Comes with pain sometimes.
Okay, so we're going to be moving on. I do not see any other hands raised. And we do not have any consideration of ordinances, so we will move on to this evening's application, which is Campus Associates LLC, file 20-PB-13-MSP. And this application hearing is continued from the February 4th, 2021 public meeting without further notice. So with that, I don't know who would like to lead the discussion, Ms. Castro?
Well, I believe procedurally, we were at the public section of the proceedings. Correct me if I'm wrong, Mr. Chairman or Mr. Bernstein. we have reserved rights to present additional witnesses. It's our hope that we will not have further witnesses.
I think, Mr. Chairman, before we open it to the public, if the applicant has indicated he has no further witnesses at this time, obviously subject to rebuttal.
Correct.
I believe at this point, the appropriate action to be taken, Mr. Chairman, is a motion to open to the public to allow them to make comments on the application itself.
Okay, do I have a motion to open to the public?
So moved. Second, Santa Romita.
Okay, all in favor?
Aye.
Aye. Okay, before we start taking commentary, I see we have 19 members of the public. So to ensure everyone has an opportunity, I'm going to set an initial 5 minutes of time. I've asked Mr. Kinsler to give 2-minute and 1-minute warnings. And at that point, we would be moving on to any other participants from the public. And once we exhaust the list, we would go back if there's anyone that has any additional, but hopefully we will get through and allow everyone to provide commentary that wishes to do so. So with that being said, anyone would like from the public to provide commentary on the application itself, please utilize the raise your hand feature or *9 if you're on the telephone. Okay. We do have one up, Mr. Kinsler.
Yep. Again, please state your name and address for the record, spelling your last name. Again, it'll be a 5-minute limit up front. I'll interrupt you at 2 and at 1, and then at the 5-minute mark, we will shut your mic off and go to the next. And as Chairman said, so again, please state your name and address for the record.
Good evening, gentlemen. Mary Ann Sawade, 142 Johansson Avenue. How is everyone today?
Good, thanks.
All good, thank you.
Good. Wanted to give you an update. I had presented the petition that I had started about a year ago, and we're up to 2,537 signatures opposing this development. Just want to give you that update. I understand the new stormwater ordinance was passed in compliance with the DEP revisions. And I had asked at the council meeting to the attorney if it would apply to this application, and he said he thought it would. Is that correct? And how would that change the current stormwater plan?
Unless Mr. Euro corrects me if I'm wrong, I don't believe it's going to change anything relative to this plan. As to whether or not it is in effect, I will indicate if the governing body adopted it Tuesday night, and I see the mayor and deputy mayor here, so they can also correct me. It's not in effect because 2 things. First of all, it hasn't been sent to publication, and all of these ordinances are conditioned upon the approval of the county planning board. But I do not believe, and as I said, I'll defer to Mr. Euro, I do not believe that the new stormwater regulations changes the application relative to the way it's being reviewed.
So I'm excuse me, I'm just perplexed. I thought we were on the comment section, and now we're going to open it up to Q&A. They've had the chance to raise all these issues. I really just don't understand the procedures here. It is a free-for-all. It's becoming that, and respectfully, this board is so transparent and bending over backwards for the public, and I love that. But there's no procedure, and if there's a procedure, the first witness, the first member of the public appears and breaks the protocol. So I really am perplexed.
The procedure, Mr. Policastro, is not normally what I would consider a free-for-all. A question was raised. There is a stenographer taking a record. And in case there is an issue down the road, I wanted to make sure that the record was complete relative to the stormwater issue. As I indicated, and I will said, defer to the township, the board engineer. It is my understanding that the regulations, A, do not change the situation at hand. B, since it was just adopted on Tuesday night, it has not been published by the township clerk and therefore is not in effect. And C, it's my further understanding that all of these stormwater ordinances are subject to the approval of the county planning board, which obviously I don't believe has occurred. So at the moment, it doesn't change anything except to make sure that there's a complete record.
Yeah, Mr. Bernstein, just a quick question or comment. So I think the view when we reviewed this on Tuesday was that while you're correct, we just approved it and there's not a formal final record yet that's been filed with the planning board. My understanding is that the criteria and the procedures and the requirements that are in the ordinance have already been sort of operating standard for DEP since last year. So we are essentially catching up with the DEP standards. So to that extent, the belief was that the new applications that are currently in process are already having to meet those new DEP requirements. So that should be the case. But I certainly would welcome any clarification on that. That was the understanding the other day.
Bob?
Yes, Mr. Chairman, that is correct. Mr. Delgore had mentioned, and just be aware that the actual DEP regulations do not go into effect until March 3rd of 2021. So it was the requirement by the DEP that all municipalities adopt these new regulations prior to the March 3rd implementation. So that's why this was recently adopted by the committee, I guess within the last 10 days.
Thank you.
Continue on, Marianne.
Thank you. I did see the Environmental Commission's letter requesting that the 150-foot buffer for the stream corridor ordinance would be upholded. And I also wanted to point out that in the land use ordinance for Hillsborough Township under stream corridor protection, under prohibited activities, it does include that buildings or structures, driveways and parking areas should in no circumstance be permitted as waivers. And I know that the court settlement had said some reasonable waivers would be, considered and allowed to make this project happen. But according to our ordinance, that there's no exception for the stream corridor ordinance. That was all I had to say on that, though. And I do hope, and I know that everyone's taking this very seriously and given it a lot of time and thought. We really appreciate it. Going forward, I just hope everybody makes the best decision for everyone involved. Thank you so much.
Thank you.
Thank you.
Mr. Kinsler, please promote the next member.
Again, please state your name and address for the record, spelling your last name, please.
First name John, last name Tutunjian, Tutunjian.
Thank you.
Address is 150 Johansson. So on my comments, and it was about a year ago, we went in front of the zoning board and in front of the committee. And at that time, there was a decision to be made to change the zoning. A lot of us got up and we started to talk about the environment and the water problems that were existing and the wetlands and this swale, which is really a stream. And we were told that that wasn't the time and place. What we were told was that the township was forced in a lot of ways to change the zoning. And the reason why they were forced and their hands were tied was because if they denied this, which in their better judgment would be to deny the changing of the zoning at the time. But the applicant could come back. And in a lot of ways, I mean, I don't want to sound, but it was like a bully move. Like, if we don't change the zoning and allow 4 3-story structures, they could come in and they could make it a lot worse. So we're going to have to change the zoning. But that doesn't mean when we change the zoning, they're not going to have to be held to the standard that Hillsborough expects them to be held to. That's a very high standard, and we all moved to this town because of that. If I go to build a 10 by 10 foot addition on my land, and this applicant and their council is appalling that they're acting like they're being treated unjust, the questions that we get are 10 times worse. Every inch counts. And the reason why we do that is to be a good resident, because we know if we build too much on our land, every inch permeable space, water problem. This applicant doesn't seem to care about Hillsborough. And as a parent, we told them we have a major water problem. They admit that this system doesn't work currently, but their way of looking at it is, that's not our problem. Your water problem is not our problem. We can add to that. Mr. Ford even said it. You're going to have water matters what. You're going to have a flood. If you have another foot, it's not our problem. That's appalling to me. And what's appalling to me is we do care about everyone around us. When this last snowstorm hit, when there was 3-4 feet of snow over our sewer grades, we went out and we dug them free. We went out. I'm sure they wouldn't do that because that's not their problem. Those are the words you got to remember. That's not our problem. Well, they want to build here. It is their problem. Anyone who came out and walked the land, from the Environmental Commission.
2 minutes, sir.
All right, from the Environmental Commission to the board members, anyone who came out and walked the land, everyone has the same agreement. Not only should this not be denied tonight, this should be denied for any future building, light industrial, residential, I don't care. Deny it, let them go to the state, work some agreement out with them. This is not a suitable piece of land to build on, bottom line. If this gets built on, it's almost like, what else couldn't be? It's unbelievable if this gets approved. It's on top of a stream, on top of waterlands, right behind a synagogue, no fence going to be put up. This is, I'm really hoping and praying, everything I've heard, all the testimony, that this gets denied tonight, and then it moves to the state level, and then we'll take it up from there. Because I don't know who's going to hear us at the state, but if they listen to all the testimony, this has to be denied tonight. Bottom line, that's all I have to say.
Thank you.
Thank you. Okay, looks like we have Ms. Gulliford with her hand.
Ms. Gulliver, please state your name and address for the record, spelling your last name, please.
Okay, Susan Gulliford, Gulliford. Hunt Club Road.
Thank you.
I had something I had asked for previously, and I don't remember seeing it unless I missed it. Did the architect ever provide, I don't know what you call it, plans showing the facade that they were proposing? I know I mentioned that orange and blue one that's in Somerville, or did they just agree to use the finishes that the township requested?
I believe that they would work with the planning and zoning to our satisfaction and the engineer.
On the architectural standards.
On the architectural standards.
Oh, okay, so they didn't provide it, but they did agree for the architectural standards. Okay, thank you. Should I also put a comment in here, or should I wait for comments?
No, this is comment.
This is comment.
Okay. I know most of the neighbors are mainly concerned with the flooding in that area. But another thing that has concerned me along the way is the area where you're putting 96 families in a development with only one exit, no emergency or secondary exit. for those times when Route 206 closes for whatever reason, flooding, motor vehicle accident, whatever. You can't even walk out of there. There's no pedestrian access, because when I asked about it, the sidewalks that they would install would end at the end of their property. It wouldn't even go out to the highway. And should you get out to the highway, there's no sidewalks. And there's no shopping, no public transportation. It's just seems like a really bad location to put 96 families and at any time, even not even considering the flooding that the neighbors are worried about. Thank you.
Thank you.
Okay, we have another member.
Again, please state your name and address for the record, please, spelling your last name.
Hi, Nancy Guancione, Guancione, 58 Campbell Road.
Thank you.
I just want to make some comments. We've lived in Hillsborough for the past 24 years. During this time, we have witnessed the overdevelopment of Hillsborough, especially late in especially the last 5 years. We're sure Mayor Lapani can relate, being a lifelong resident. Prior to Hillsborough, we lived in Piscataway for 30 years, where when we go back to visit, it's unrecognizable due to the rampant development everywhere. We're afraid what's going to happen, what happened to Piscataway is happening to Hillsborough and in a rapid speed. We know there's open space, but there needs to be more. We agree with the gentleman who spoke earlier that this area should not be developed and deemed open space. Might be a moot point at this time, but I wanted to mention that. And I think this town is placing revenue over the environment, wildlife, and the people of Hillsborough. It's very sad. I think development has got to slow down. Thank you.
Thank you.
And next, Mr. Colmer has his hand raised.
Again, please state your name and address for the record, please. Unmute yourself.
Hi, Grant Colmer, 144 Taylor Avenue. Just make sure that I'm procedurally doing this correctly. This is just public comment on any agenda item or just?
On the application.
Thank you very much. Appreciate it. The comment I have is really listening to the testimony last, February, whatever that it was pretty alarming to hear sort of the engineer and their aspect towards it. And they did a fine job in speaking towards his client and what they were managing to propose and sort of the planning and development of this area. But the words that rang out to me most closely were as follows. Was, and I'll paraphrase because I didn't write it down, but it was stated of something of the nature like, there's already flooding in this area, and no matter what we do, there's going to continue to be flooding. Now that's extremely concerning, considering an area that's already flooding, and you're going to add more water to the system. And the sheer fact that they know that this is going to happen is quite alarming. Super alarming. And I hope that the planning board really takes that into consideration. And I would ask each one of you to consider that statement to say, if you lived here and you knew there was water already coming in and there's going to be even more water coming in, what would you do? And what repercussions would you have? And please protect our community that's in here. That's all that I have. Thank you.
Thank you.
Let's see, we have a phone caller.
Yep. Again, the person on the phone, you need to press *6, state your name and address, spelling your last name, please.
Hello?
Yes.
Okay.
Please state your name and address for the record, please. Spelling your last name.
Yes, it's Maria Janusic, Janusic, 720 East Freck Avenue, Manville, New Jersey. I had submitted a request for government records through the Open Public Records Act in January. I had requested a copy of all of the freshwater wetlands permits that were granted by the NJDEP, Division of Land Use Regulation, to Campus Associates, LLC, for the residential development proposed for Block 58, Lot 1.05. And the response I received was, no such record exists. I submitted another OPRA request. I asked for a copy of the fully completed Department of Land Use Regulation form, as was submitted for Hillsborough Township Block 58, Lot 1.05. The response I got was that this request requires an extension to complete. I was going to get a response by January 25th. The response that I got, let's see, on January 25, which was not that long ago, copy of the fully completed Department of Land Use Regulation form as was submitted for Hillsborough Township Block 58, Lot 1.05. And again, no such record exists. So no permits to date have been provided by the New Jersey Department of Environmental Protection, and yet we're talking about approving this application. I think that's very, very premature, especially with all the comments everyone has made about flooding and all of the wetlands and everything that's on that property. And there's a conservation and wetlands easement on that property. So I don't know how this can even be considered at this point. Thank you.
Thank you very much.
Okay, we do have another hand raised.
Again, please state your name and address for the record, spelling your last name, please.
Yeah, Alberta Albanus, 42 Stonewick Drive. I'm only in Hillsborough for 15 years now, but I moved out of Somerset because I liked Hillsborough. It was a lot of open space. And I agree with everybody that's been talking. I'm not really happy with all the building and everything that's going on, especially, around the wetlands, et cetera. So I'm just agreeing with everybody. I came here because I liked the open area. It was more like country. It's getting way too built up. 206 now by all that building that's being put up there by Bottle King, that's going to be a nightmare. That's what I don't like. And I'm just want you to know, I want you to know my opinion. That's all.
Thank you.
I see there's a Scott. Please promote him.
Yep. Please state your name and address for the record, please, spelling your last name.
This is actually Christine Koppen, Koeppen. I live at 7 Magdalene. The other resident is Scott. Being open for comment right now, I don't know if it's appropriate to raise a question, but I don't know if there was ever a ruling on the application for the letter of interpretation about the official wetland boundaries. Has that been finalized? And if I can't ask that question, what I'd really like to state is I'd hope that this planning board would give us the opportunity to understand what the true wetlands are and the interpretation of that and the true impact this is going to have to our community and what's around us. Should I pause for can I ask that question? Do we know what the official boundaries are on the property?
Mr. Earl, you want
to? Yes. So and I believe Mr. Ford, the applicant's engineer, can confirm the letter of interpretation was issued on the location of the wetlands, which pretty much run within the southeast quadrant of the property, and they do run along the drainage feature that has been under discussion for the last couple of meetings. I believe the LOI has been issued. I believe the further permits or applications that have been submitted to DEP regarding some buffer averaging or transition area waivers have been submitted, but have been rescinded and need to be again resubmitted due to comments that the applicant has received from the DEP. But I believe Mr. Ford can correct me on that timeline.
Thank you.
So with that said, we know there's wetlands on the property, and we're all really struggling here to know what we should do and how we can protect ourselves from what's happening to us. You've heard our stories. You've heard us ask you to help us repeatedly on this issue. And I would hope that you could help us by not taking this application, not allowing any waivers, to keep as much of the property intact as is on the wetlands that we can. I'm not really sure what else I can say. This is the comment portion of it, but please, we need to preserve these wetlands. This is part of our community. And I would hope that you would at least deny the application, deny any waivers or any other applications in front to make any other adjustments that would touch those wetlands. Thank you very much.
Thank you.
Do not see any additional hands.
I do not either, Chairman.
So I'm just going to give those who may have spoken already another crack or another bite at the apple if there was anything additional. Because I know we're given 5-minute time limits.
Yep. If anybody else would like to speak, now's the time to raise your hand on this application for public comment, please.
I see one.
Yep. Again, please state your name and address for the record. Spelling your last name, please.
Richard Mann, MAHON, 120 Johansson Avenue. For as long as I've lived here, I guess there may be a good reason why this property hasn't been developed over the past 45 years. A lot of my neighbors have already made comments regarding problems in the area, so I'm not going to go over that. There is a flooding problem, but there's one other thing that I'm concerned about. When Dukes Parkway East floods and 206 floods, we can't get to Somerset Hospital. You can't get there through Raritan, the back way through Dukes. You can't get there at 206. You can't get there on South Bridge Street, and you can't get there through Manville on Findern Avenue. So if there was an emergency at those apartments, where do they go? Probably can't get to New Brunswick because Manville's underwater. And if you think about River Road and Millstone, that's underwater also. So what direction does anybody go if they can get to the apartments? Because our development gets flooded in. We can't get out and nobody can get in. So I think there's a safety concern putting residents in those apartments in jeopardy if there's a flood and emergency services can't get to them. Now, we've been lucky since Hurricane Irene in 2011, but our luck's going to run out again one of these days. That's all I have. Thank you.
Thank you very much. Anyone else? I see none, Chairman.
A couple more moments. Okay. Not see any. Mr. Bernstein, what's our next course of action?
Motion to close public.
Okay, I'm going to give the public one more chance before I ask for a motion to close. Nope.
All right.
Go ahead.
And then if you're on the phone, *6. Again, please state your name and address for the record again, spelling your last name, please.
Hi, it's Maria Janusic, Janucik. The gentleman that just spoke made a very poignant comment that property was not developed because there are wetlands on there and they're protected, and also it creates flooding. So that is a reason why that property wasn't developed for all these years. And I see also that there are other developments that are ready to be go forward, and those properties also have lots of wetlands, and they have sat for a long time for the same reason that there are wetlands and there are restrictions. But now with this affordable housing, there's ways to bypass all of that by having a judge order zoning changes, and I don't know where the judge gets that authority. I thought he's supposed to follow the laws that are on the books and not order someone to make changes in their ordinances in order to accommodate a property owner, because this ordinance is specific and solely for one property owner. How is that fair to anyone? Or even, I question if that's even something that should be done. So this issue with this land, it wasn't built on because there are wetlands, because there's streams, and because there's habitats for for different animals and birds. And so this application is really pretty pathetic. Thank you.
Thank you.
Okay. Last call. Okay, I'm going to ask for a motion to close public.
So moved, Mayor Labani.
Second.
Okay, we have a motion and a second. All in favor? Aye. Okay.
Mr. Policastro, any last words?
Are we moving toward a vote, Mr. Bernstein?
Well, we're moving from the public portion, so I assume we'll eventually be moving toward a vote.
Yeah, I would just say, you know, the ordinance in question does not apply. If it does apply, we've applied for a waiver. We've satisfied the MLUL. And NJDEP is the most aggressive, demanding agency in the country. That's public knowledge. And we're satisfying the requirements of NJDEP. Not easily, but we're doing it. And those are my final words.
Mr. Chair, can I have a couple of minutes?
Yes, go ahead.
Okay, so since the last meeting, we did have another session at the Environmental Commission this last Monday night. And I know Ms. Swade referred to that letter, but it's worth noting because the way I see it, there's two issues. One is the applicability of the Hillsborough Township Stream Corridor Ordinance. And the other is the stormwater issue. So since the last meeting, I've had time to kind of think of a couple of different scenarios, maybe some workarounds, you know, maybe some potential fixes, maybe some food for thought, but it's worth talking about it, at least at this point. So at the commission, and it's worth just reading for a second, the applicability of the Stream Corridor Ordinance. Obviously, the Environmental Commission has the power to study and make recommendations concerning, but not limited to, water resources. The Ordinance 188.64A notes the natural features such as a stream shall be preserved whenever possible. The ordinance notes that our stream corridor protection complements what the DEP already has in place. So the ordinance doesn't conflict with the NJDEP regulation, actually enhances the regulation by creating a larger buffer zone. So we're saying, or the Environmental Commission was asking the board to apply the Stream Corridor Ordinance as written. So the applicant is not asking for a waiver. What the applicant is saying is that they don't agree that the Hillsborough Township Stream Corridor Ordinance is applicable in a situation. So instead of letting a judge decide that, it might behoove the applicant to actually ask the township for a waiver and try to do some different techniques such as buffer averaging, mitigation, rain gardens. There are things within our ordinance that might be a solution, might even be a workaround. So that would be something that might be an avenue to look at. The other issue is—
May I interrupt you? Why are you saying that we did not ask for a waiver?
Well, you said that. You said you're not asking for a waiver. You're basically saying—
It's in the transcript from the last hearing. No, I said it doesn't apply. If this board somehow deems that the ordinance applies, then we've asked for a waiver and we've noticed for a waiver, and the settlement agreement contemplates that waivers would be granted.
Well, to ask for a waiver though, you would have to ask for a hardship waiver, and within that hardship waiver, the way I understand it, there would have to be certain requirements and mitigations to kind of implement to request that waiver, the way I understand it.
So we've put those proofs on the record. with Mr. Affenord and Mr. Ford, we stand by those proofs, and we are ready to go to the judge. If we have to go to the judge, and this board denies it, we're wholly confident that, as you say, a judge will decide it. The ordinance doesn't apply. DEP is the most stringent regulations in the country, and we're satisfying DEP.
Yeah,
Look, may I?
Go ahead.
Of course.
Mark, earlier this evening, about 40 odd minutes ago, you raised a question about people having a quote free-for-all. Board members have the right to make their comments at a point in time before the board takes an action. You and anyone else on your behalf are more than welcome to respond therein. I would like to let my board members who have sat quietly by through all of these hearings get their thoughts out in one opportunity, and you can address them accordingly.
Of course, that's I requested permission.
Well, you know, you sort of, but that's beside the point. The answer is,
I'm all about the protocol.
But I thought that you're not requesting a waiver from the stream corridor ordinance. You're just saying we don't want to abide by it. That's the way I understand it, correct?
Mr. Policastro, in spite of my comment about 90 seconds ago, if you would like to clarify your client's position.
I think that's like saying I smoked, but I didn't inhale. Okay, we were asking.
Well, we've had a president who said that, you know.
Aware. We are requesting a waiver as necessary. We don't think we have to get to that point because we believe the ordinance does not apply. And we're standing by our proofs made by Mr. Affenord and Mr. Ford in that regard.
Okay, so I would contend that the ordinance does apply.
I'm aware.
But let's talk about the stormwater for a second. So, I mean, I was out there, I did walk the property. I do think that it is a situation that could be looked at from a regional standpoint. There are things out there that Hillsborough Township could look at. There are some things that Somerset County could get involved in. There are things that the Environmental Commission can take a look at in terms of approaching it from like an all hazards mitigation plan. It's not entirely, it doesn't entirely entail just your property, but there are other issues, like I said, on a regional basis. But I think that it would behoove the applicant to be part of that process, to kind of look at the watershed itself, along with Hillsborough Township, possibly along with the Environmental Commission, possibly looking at grants, and possibly involving Somerset County also, to kind of look at the entire watershed there, because it does involve obviously more property than what you're building on. It's just not, it's not a one solution type of thing. There are other things. There's a detention basin that, you know, is kind of upstream there that's not really working properly. There's other issues. So, you know, I think it's worth considering, again, to kind of look at it from a bigger picture, to try to mitigate it, to try to work with the neighbors, again, with the county, with Hillsborough. Even, like I said, even see if there's some grants to be able to look at this thing from a mitigation standpoint for the entire watershed, because whether you build there or not build there, some of those problems are still going to be there regardless. So I would ask, you know, if your client does get approval for that, I would ask you to look at that, like I said, on a larger scale than just your development alone, because I really think it is a regional problem. And I think the township, you know, has some responsibility, along with, again, the county and other entities, to kind of take a look at that whole thing, because it was a problem before you were there. It's going to be a problem after you're there as well. So I just wanted to throw that out. Again, food for thought, you know, and maybe there's some paths forward or other things that can be done. So I wanted to just say that, and that's all I have to say. Thanks.
Thank you, Neil. Any other board member got thoughts?
This is, can you hear me? This is Mr. Emick.
Yes, we can.
Eric, can you help me understand the applicability of the stream corridor ordinance and as it relates to the DEP? I understand that the applicant still has to get some DEP approvals. And I believe, and maybe someone can correct me if I'm wrong, obtaining those DEP approvals will determine exactly where the wetlands are and the stream corridor that might or may or may not exist on the property. But how does the stream corridor ordinance relate to the DEP? Is it applicable? Is it complementary?
Well, let me start by discussing the applicant's position so that, and I'm sure Mr. Policastro will correct me if I am wrong. It is the contention of the applicant as to this project that they have delineated the wetlands subject to DEP approval of that delineation, and that they believe that, and their expert, Mr. Affinord, has indicated that that this culvert, or whatever we're calling it, is a stream, but they are bound by a 50-foot buffer from same in accordance with a LOI that has apparently been granted by the Department of Environmental Protection. Now, separate and apart from how you characterize the DEP regulations are not maximum, they are minimum. There is nothing in the DEP regulations when it comes to these kind of issues that says you shall not go beyond a 50-foot or 150-foot or a 500-foot or 1,000-foot, and there are multiple buffers from multiple issues that DEP raises. You cannot go below it, i.e. the applicant or the township could not come in and say, okay, we're now going to grant 25-foot buffers to any one of a number of items that currently are limited by DEP to no less than 50. There is nothing, however, in the regulations that I'm aware that says that a municipality cannot impose a condition or a standard greater than what the DEP has established unless the DEP has indicated that a municipality or a county does not have the jurisdiction to do so. I am unaware in this situation that a municipality such as Hillsborough has been foreclosed from the potential imposition of a buffer area larger than a 50-foot buffer. Obviously, greater minds than I and Mr. Policastro, though he may disagree with that comment, may have to make that determination ultimately. It is applicant's contention that the 50-foot is the 50-foot is the 50-foot, and whatever the township has put into place, it is bound by the DEP determination. I would argue that DEP has not precluded the township from imposing more. I would, however, make the following point in general. If this board, I apologize for saying governing body, if this board were to determine that the applicant is governed by, in this situation, a 150-foot buffer, I would indicate that anyone along this channel, culvert, stream, etc., is equally bound by the 150-foot buffer and the waiver provisions therein. And what the board may have to do if they determine that that 150 applies, and obviously the applicant's current application does not comply with the 150-foot, but does comply with the 50, is whether or not the board would grant waiver, one or more waivers necessary to allow the application to be constructed in its current situation, or ask for additional information, or deny it and deal with the issues accordingly. You've heard Mr. Policastro on that. You've also heard from Ms. McManus. But I would indicate that while the ordinance that was adopted pursuant to the settlement agreement between the parties sets forth the general conditions, there are provisions in that agreement that indicate that the applicant and the board will be bound by applicable ordinances and regulations, and that the board should at least give a consideration to the suggestions made by the Environmental Commission and its representative this evening. And I would concur with Mr. Policastro that his client has made application for a waiver under the ordinance, assuming that the board would interpret that that applies. The board at that point could request additional information or want additional guidance from my office as to whether or not such waivers can be granted, and if so, under what conditions, subject to what Mr. Policastro and his client want to do relative to same. But I think, Mr. Emick, and stop me if I haven't, I think I have tried to answer your question relative to such.
Yeah, Eric, you've done a great job of answering it. That the notion of a waiver for the stream corridor, I thought I heard somebody say earlier that by no means does a waiver be granted for a stream corridor infraction,
No.
for encroaching. Does Hillsborough have a precedent of?
Well, Hillsborough doesn't have a precedent, but I would point out to the board that the provisions of Ordinance 2005-02, which have been codified in Section 1, Chapter 188, Section 46A of the Township Code, subsection D, provide for multiple waivers and the criteria for such. The prohibited activities not set forth in A, C, and D within the waivers are prohibited, but I don't think you can make a blanket determination that the existing of a parking lot is not necessarily a denial of the possibility of a waiver. I think you have to look at it in a more overall scheme as to the application itself. And if the board were to make that determination that they wanted to review a waiver, there are multiple options available to the board in making that consideration.
Okay. I do have a question for Mr. Euro, and I think I've asked this question, but I just want to be sure that I understand. Mr. Euro, can the applicant shift the direction that the water from the site is going to? That in my day job, if you will, I've had experience where because of grading, we have impacted the direction that the stormwater flows, and we worked with the Delaware Raritan Canal Commission and actually changed the direction that the water, the stormwater was flowing. And is there that opportunity here to direct the stormwater, away from, I believe it's the stream that's to the north? Can it go out towards 206? I know it's ending up in the same spot ultimately, meaning the branch of the Raritan, but to kind of shift it away from the neighborhood. Is there that opportunity or no?
So Mr. Emick, Mr. Euro here. Obviously, anything can be engineered to make water go wherever. The rule of thumb is that you try to follow the existing drainage patterns, and right now the existing drainage patterns flow from the southwest to the northeast, similar to what the applicant has proposed. Can you reverse the direction and make the water go out to 206? Yes, but I do not believe that you can do that via gravity. You would have to provide some sort of a pumping system to do that. Is it recommended? No. But obviously, you can engineer anything and make water go wherever you want it to go via mechanical devices. But the rule of thumb is if the water flows in a certain direction in the existing condition, you want to maintain that direction in the proposed condition, which is what this applicant has done.
That's helpful. And in the instance I was speaking of, in my personal experience, I think we had the luxury of we're on the crown of the site and we didn't need to mechanically use pumps to get it to go in the other direction to the other, kind of drainage corridor. So helpful. Thank you.
You're welcome.
That's it for now. Thank you.
Thank you.
Mr. Chairman, I have just a question first. Mr. Euro, I know we had asked Mr. Ford and the applicant if they would or have done a downstream analysis that we had talked about prior. Do you know if that was ever done or submitted?
Mr. Mayor, no, I have not received any information on any downstream analysis on that existing 42-inch pipe.
Okay. I'll hold till my last comment till everyone else is done. I'll leave it to the chair.
Any additional board members? Deputy Mayor, you look like you're fidgeting.
Yeah, sorry, I was on mute. So I just wanted to kind of do a little bit of a reset for some folks, because I know during the comment section, there's always concerns around just overall growth and development and the impacts to this development and others. And we have had multiple sessions. We've had multiple periods where we've talked about how we got there. I know Ms. McManus is on the phone and she knows firsthand. Unfortunately, in many of the cases that we reach out or that we try to do some of these projects, this is a result of affordable housing requirements, pure and simple, and those are the directives of the state, most notably the Supreme Court at the state, and the requirements that every municipality in this state has to meet certain obligations. And we are no different than that. So while do I wish it was the case? Absolutely not. And we had a 2-hour town hall last year, or 2 years ago, I guess, on this exact topic, because there's a lot of concern around exactly what it means for everyone here. So I just wanted to let, especially some of the comments regarding growth and development, if there's a concern, and we have them too, and we share them and we recognize the problem is the growth requirements have not been considered with infrastructure, with schooling issues. Those are all secondary thoughts. It's, let's get affordable housing built in every municipality in the state. And when there are applicants that bring affordable housing projects to the fore, we're obligated to listen to them. And that's part of the plan that we worked with the court process. That does not mean that, and I please don't misunderstand me, that does not mean that any application that's got affordable housing is required to be considered if it's outside of the scope of things that we have in place in terms of ordinances or requirements. It's just the reality of every municipality dealing in the state right now. And this has been ongoing, not just now, but this has been I don't know, Eric, you tell me, 30 years? But
40.
But
45.
We're at the aggressive stage now where stuff has to be built. So not excusing, just want everyone to understand that if you think that there's that the town is shifting in the way it is growing, I urge you, as we have in the past, to go call your state legislators and make sure they understand that we're tired of building affordable housing throughout the state. And because at the there are the local level activity is kind of bound by the things that we have in place in terms of ordinances and requirements, whether they're local or DEP. And we're gonna, those, we've talked about a lot of those. So in this case, it's, that stream corridor, it's got to do with, the wetlands, it's got to do with water remediation. All those things have to be considered in decision making. But I've been on this soapbox for a while, and I just wanted to get back on it so that everyone understood some of the basis for how we're here.
Thank you, Deputy Mayor. I was going to echo those sentiments, or actually, direct the public to go to the Hillsborough YouTube channel to watch that town hall, because that has an enormous amount of information, including the history as to how we've arrived to this point in time, and it's not ending, because I do believe the next round is only about 4 years away, that the process is going to start all over again. So, any other additional comments from the board members? Because I know the mayor's gonna.
Mr. Chairman, I don't want to prevent the mayor from speaking, but I think if no other board member has a comment, I think you might want to hear from the board professionals other than me, relative to whatever else they want this board to consider as a possible action.
So, Mr. Mayor, if you could wait. All right. So, Mr. Maskey.
Yes, thank you, Mr. Really most of a summation more than anything in terms of what's being requested. Obviously, site plan approval. Variances are being requested for the height of the accessory building, the height of the freestanding sign, removing more than 20% of the trees on the site. A waiver is being requested. It's an economic hardship waiver, has to do with tree mitigation. As the discussion as we have just discussed, there is a stream corridor waiver being requested. And I know there was some discussion about what conditions and whether or not it can. The ordinance does allow for waivers under one of the circumstances in particular, if the stream corridor width may be reduced, provided there is an equivalent increase in the width elsewhere on the site, in other words, stream corridor buffer averaging. Those are the only variances and waivers that are being requested at the current time.
Okay, thank you. Mr.
Yes, thank you, Mr. Chair. Again, Mr. Ford had provided testimony and agreed to most of the comments in my various letters. The one thing I just want to circle back on is that we do get confirmation on the resubmission of any applications to the DEP for their buffer averaging. Other than the statement was made, and it's been testified to that the LOI has been issued in 2017. I believe the buffer averaging application, as well as the flood hazard application, was initially submitted and then rescinded or removed from the DEP, and it needs to be resubmitted. So we need to get confirmation as to when that will be resubmitted to the state, and copies of the necessary applications. And again, circling back on all of the concern that the public and board members have had regarding the drainage, I still believe it is necessary that this applicant provide some sort of a downstream analysis on the existing 42-inch pipe, just to confirm that the drainage that they are going to be putting into that drainage feature will not exacerbate the existing system. Thank you.
Thank you. Let's see. We're out of professionals, right? Mr. Bernstein?
Mr. Chairman, if I could ask for a couple of moments for a break, and I think I've covered most of what I have to cover, unless the board has additional questions beyond Mr. Emick. I would ask for a 2-minute break.
Okay, so looks like it's about 8:48, and I'm sure Mike could use a break too. There's a lot going on. So let's reconvene at 8:55 in about 7 minutes.
Okay.
Okay, everybody just shut your video, mute yourselves. Thank you.
Thanks, Fred, for being so quick on that one.
No problem, Kurt. Thank you.
Thanks. Eric, I'm not always in the car.
Yeah, it's nice. It's nice to know you've been sent to the laundry room. It's all right. I have mine. I had a mute among many things because my wife decided to walk in. Ken's doing his Ron Scobo imitation with the green backlight. You know,
I got some light here.
Yeah, it's good to see.
Answer the questions.
And Mike, congratulations. You had wife had the baby?
Yep. Thank you. Thank you.
Boy, girl?
A boy. So I got a girl and a boy. I'm done now.
Ah, congratulations.
Congratulations.
Does your wife know?
Another Devils fan, right?
Does your wife know that?
We actually brought him home in a little Rangers outfit. Actually, we're setting him up right.
At least you brought him in a hockey. At least he's a hockey fan. That's good.
I haven't been subjecting him to the games
I might
lately.
have to end this meeting, Mayor.
Well,
This is
all you
awful.
Flyer fans need to quiet down.
Where's the administrator? One of the good things about him.
Yeah.
Thank you, Mr. Chairman.
Not a problem. Looks like we
Mike,
just.
I assume you're going to do the obligatory roll call now that we're back.
Yes.
All right, yeah, I'm waiting for Bob and John.
Triccarelli, you want to put your camera on if you're there? So
Let's see
there
your
we go.
small face. There he is.
All right.
All right, great. So, Mr. Emick,
Here.
Mr. Ciccarelli,
Here.
Mr. Peason,
Here.
Mr. Senator Amita,
Here.
Mr. Hedstag,
Here.
Deputy Mayor Delcor,
Here.
Mayor Lapani,
Present.
Vice Chair Julian,
Here.
and Chair Sirachi.
Here. Okay, so we're reconvened. Mr. Bernstein,
Yes, we are.
okay,
As I said, Mr. Chairman, before, I appreciate the break. If the board has any questions of me, other than that raised by Mr. Emick tonight or any other before, I'll be more than happy to answer. Otherwise, I think I have made my various comments on the record.
I do have one more question for you, Eric. Can you play out a situation here? What happens if there's a denial? What happens on the affordable housing front for the township? Do you
Well, I won't speak for council, but I can assume that if this board were to deny the application this evening, that they would seek a decision in front of his honor relative to a breach of the settlement agreement. And I would suspect that Ms. McManus, who was also quietly sitting by, will probably learn how to call me on the phone and, ask me all kinds of happy little issues. And I would suspect that Fair Share won't be too far behind. Does it mean that we will lose our immunity overnight? No, I don't believe so. I think we'll have to address the issues accordingly, but it will be, let's say, a bumpy ride.
Does it mean that when we lose our immunity, our number changes?
Quite possibly, and it leaves us under the worst case scenario, potentially open to worse building than the people who have commented upon, who are worried about the building in town, may in fact wish that this was the hardest part they have to deal with. So I don't want this board to, this is not the traditional land use application which comes before the board and the board either rejects or accepts. There are additional issues and consequences that potentially may come about based upon the actions of the board.
Thank you.
thank you. Any additional questions, comments?
Can I, and this I guess is also for Eric, and I'm going to jump on Kurt's thought process here. What is the worst case scenario that would happen if we do approve this and for whatever reason, unforeseen by the designers who have testified, that the flooding gets worse?
I would anticipate, and I can't speak for other people, and if I could predict what would happen, I would be playing the lottery a lot more and spending a lot less time here. That individuals who believe that they had been adversely affected and who had suffered damages or claims for damages could bring an action against the township, the developer, and other entities, including DEP, claiming that in fact actions that were taken relative to this application adversely impacted them to the extent that they had something provable that they could indicate was a viable claim. It's not an easy situation, but you know, that's what could occur.
Are we held harmless by anybody?
You can make the argument that your actions are entitled to either absolute or qualified immunity. It would depend upon how the case was pled, what the arguments were made, and whether or not the court believed that in fact the township had, or the board, or both, had done what they needed to do in order to assure that they had not, in fact, violated the potential immunity provisions. But a lot of that depends on how it's pled and what the proofs are. Or that. I.e. the barking in the background.
That wasn't me.
Okay.
All right, thank you.
Anyone else?
Mr. President, I got a quick question, because I know it was raised about regarding a downstream analysis. I believe Mr. Earl may have commented on that. You know, that that there may be some desire for one. You know, how would could that be handled tonight?
As a condition of approval.
And what would that condition actually?
That the applicant would have to provide a downstream analysis as determined by the board's engineer in conjunction with the applicant's engineer and applicable regulations, and set a time frame. And I believe that part to Mr. Euro, and to when to receive same, and depending upon the result of such, the board may require a reappearance by the applicant relative to same.
Eric, is there any possibility of my recommendation, which is, you know, looking at the entire watershed from a more regional standpoint? Like I said, the downstream analysis, you know, might be good, but it is not going to address the whole picture anyway.
If the applicant were willing to participate in a regional analysis with other parties, then obviously is always of interest. I'm not sure, however, that the board could require as a condition of approval that a regional analysis be done. I would argue, and I think it's what you're trying to argue, Neil, is that it is in everyone's interest, and everyone being the board, the township, the applicant, the neighbors, the environmental commission itself, that we try to see what we can do going forward relative to this, because if the application is approved and starts to be built, the applicant just becomes one more party in this happy little adventure relative to potential claims related thereto, which at the moment they're not necessarily directly involved in.
Yeah, no,
as to an open piece of property.
That's exactly my point. So,
But obviously, and I won't speak for Mr. Policastro, that would be up to his client as to whether they would want to participate in such, but I don't believe that the board can require it as a condition of approval.
I would agree. The board could not do that even if we were not in a COA stance, and we are, but if this were a quote unquote regular application, the board cannot do that. It's a regional problem. And so I agree with that with Mr.
I
Byrne.
do, however, believe the board can place a condition for a downstream analysis irrespective of whether this is an affordable housing application or not.
Within reasonable limits. It would have to be reasonable. It would not be without reasonable limitations, of course.
As I said, Neil, if the applicant were interested in participating, it could do so now or in the relatively immediate future.
yeah, I mean, I think it behooves everybody. I think it behooves the township, the neighbors, the applicant, all parties concerned. So I don't think it's going to go away until that type of that type of strategy is thought about and implemented in some capacity. So I hear everybody, and I'm trying to look for a reasonable way forward, and that's why I bring it up.
Well, one reasonable way forward is for the various parties, not including the applicant, to go forward with such, with the applicant leaving themselves, for lack of a better phrase, open to the issues that may come about depending upon the findings of the analysis.
I'm just not sure that could be part of a condition.
I'm not suggesting it's a condition, Mark. I'm merely indicating that one option available is for all the parties other than your client to participate in same, and for the sake of this discussion only, and for the record as a discussion only, if it were determined that actions had to be taken which impacted your client, the anticipation, I suspect, would be that your client would have to participate in the impact as it relates to their development. So that's why I suggested that if they wanted to be part of it, it probably makes more sense to be part of it than to let the train leave the proverbial station and them finding themselves having to address what happens after the train left the station. It's not a condition. It's not a requirement. It's just what I would indicate to be a certain amount of common sense, especially knowing the property we're talking about. But obviously, you and Mr. Weiss would have to confer, and obviously, I would then point out to the board, you cannot make the regional issue a condition of approval. Any other questions, Mr. Chair, of any of the members of the board as to me?
Well, just kind of a follow-up on what you had, your answer to my question, saying that a downstream analysis could be made a condition of approval, but we could bring the applicant back. So I'm just trying to understand that process.
Well, I would indicate, well, I am Mr. Euro, and I'm sure Mr. Policastro, and if Mr. Ford wants to speak, him, that depending upon what is found, if there is an impact based on the downstream analysis that is related to the applicant, I think it probably behooves Mr. Policastro and his client to come back and have a discussion about how we're going to deal with that. However, if it were determined that the downstream analysis produced a situation that did not necessarily impact Mr. Policastro's client, then I'm not so sure we could force him to come back to the board or the township or have discussions regarding saying if that was what the downstream analysis found.
Right, and I would understand that. It's just more about if the downstream analysis saw that there was a negative impact.
Well, I think part of the issue with the analysis is going to require some parameters to be addressed so that that's addressed in advance of the analysis being done.
Okay. So
I'm sorry, go ahead.
No, I was just gonna, just with the now, because it said depending on what the results are there clearly defined, limits or, I don't want to call it, because we're basically talking about the capacity of that pipe.
Parameters.
Right. Is there clearly defined what's the maximum capacity that pipe could be loaded? I mean, is that clearly defined in any statutes?
So, Mr. Chair, Bob Euro. So basically, I understand the concern is, and from some of the testimony from the adjoining property owners, is the existing pipe. The upstream portion is 36, and then it makes its way into a 42-inch pipe as it transitions across the applicant's property, the property in question tonight. I would indicate that using a point approximately 200 feet downstream from the northeast corner of the applicant's property, or property as part of this application, would be a transition point, and that the applicant's engineer do an analysis of everything that's draining into it from upstream of that. So they would do basic drainage calculations, indicating the area in question based on the topography of the area, the impervious area that's already in place, using existing zoning conditions as to what could potentially be developed, to determine that the size of that pipe can handle what's being put through it today. And then they take it one step further to indicate that with what the current application is producing as a discharge, will that new discharge into that pipe make the condition worse? Can the pipe handle it? If the pipe is flowing at half full in the existing conditions before development, and the water that this applicant puts into it makes it only flow two-thirds full, then the pipe is sized properly and can handle this development. That's the analysis that I would be looking for. If it comes out that the existing pipe prior to development is already flowing full, then it's a discussion that the applicant would have to come back to the board, and then it becomes a question for everybody. Does the whole system need to be upgraded? Does the town get involved? And then who's responsible from that point forward?
Right. But would construction then be allowed to continue, or is that?
Well, I think if those calculations prove that the existing pipe does not have the capacity, they would have to come back to the board, and there would be a discussion that we would need to have. And there'd be further discussions as to what's happening even further downstream than that's not due to anything that this applicant is producing.
Yeah. So
and that goes into Mr. Julian's comment about a regional analysis of what's happening downstream.
Mr. Euro, could you repeat the last sentence on the regional? I couldn't make that out. I'm sorry.
I'm sorry. If we find out, based on a downstream analysis that is provided by your client, that the existing pipe is at capacity, then it becomes a regional issue. And the determination then becomes, does the township get involved in doing the regional analysis, which is even further downstream than the 200 foot that I recommended, to see what kind of upgrades would be required.
Right.
And obviously would not be the requirement of your client, but it would have to be determined how those upgrades would have to be funded and put into place.
Downstream and upstream, possibly.
Further downstream from this property, definitely, yes. And potentially upstream.
Yeah, I mean, we'd have to see the language in the condition, obviously, but any condition that requires us to come back based on these findings before the board, if we could otherwise satisfy Mr. Euro or the township engineer, then I would believe that would be enough. So it's a slippery slope to require us then to come back automatically to the board. We're not going to be able to engineer that language, I don't think, in any approval resolution, if to the extent this application were to be approved. But we, at a minimum, I'm going to need a couple of minutes to speak with my client at the appropriate time before we go that.
Well, Mr. Euro, I assume that one possibility, so that it's on the record, is if an analysis were to determine that the pipe needed to be resized because of this application, that obviously there may be some costs inherent on all parties relative to the resizing and such.
Yes, that would be correct.
And who's all parties? The applicant and
the township, etc.
Any future development.
And any future development as well, either upstream or downstream.
Yeah, and again, I think the critical language in the any condition would be to the reasonable satisfaction of the township engineer.
Oh, I don't disagree with that, Mr. Policastro. I just think, or the board engineer in this case.
I'm sorry. Yes.
So, anything else? Since nobody supposedly had any questions.
Not hearing, some shaking heads. So I know the mayor, I know, wanted to have some final comments.
Thank you, Chairman. First of all, I'd like to thank everybody on this board, including our professionals. Some of these applications are easier than others. Obviously, this one is different. I'd like to thank the public for their passion and their input. It makes the transparency for everybody better. Our EC, who isn't with us today, their work. It is Mr. Maskey, Mr. Euro, probably did more math on this application than probably any other application we've had in a while. And then obviously the applicants, professionals, Ms. McManus and Mr. Ford and Mr. A, we'll call him. From a personal standpoint, when you become involved in the township and you sit on these boards and commissions, and in my case, and Mr. Delcourt's case, on the township committee, you take an oath to work for the best of the township. Sometimes those decisions are hard. And quite frankly, in a perfect world, may or may not be made. But the charge is to represent all of the township and to do the best that you can to fulfill that obligation. That being said, certain circumstances will arise at certain times where you need a more narrow view on things. And I believe that this application might be one of those. We have a very difficult, though I do understand, it is a settlement agreement that we are obligated to via, as it mentioned, over numerous times. Because I did sit on the planning board here when we did the settlement agreement to change the zoning. We hadn't seen the plan yet, and we said repeatedly at the time when the public came up was during the planning process, this is when you get your questions and our questions answered, because we had not really seen a plan yet. We'd seen it's a general plan, but not the plan. And it is, in my opinion, based on some of the recommendations from our EC and Mr. Julian, and Dr. Bobrupta and Mr. Foley, who are very, very well qualified professionals in the environmental and with our ordinance, that I do believe that there's some discrepancy there, that I believe that our ordinance should be imposed on the 150-foot buffer. And also, when the test is made, and I'm not Ms. McManus, I can correct me if I'm wrong, you have the test of the benefits versus the detriments. Obviously, the benefits would be we were providing some 23 affordable housing units and other housing units for a needy population, which Mr. Delcor has indicated that we've been doing in good faith throughout the township for the last 40 years. I believe that the detriments of this particular project, as presented by the applicant, does not meet that proof. I believe that we have an existing property that has issues. We are not completely satisfied from what I hear on this board, and there's plenty of questions as to whether the application will remediate any additional issues on this property. And therefore, it is my opinion, and I am fully aware of the consequences, that I will make a motion to deny this application as submitted and be willing, obviously, I'm sure it'll go to Judge Miller and maybe they can have some improvements and come back and we could hear it again. But as submitted, I am not completely comfortable nor willing to risk our neighbors to the north any future detriment until I am completely satisfied that this application is a good application. So therefore, I make a motion to deny it. Thank you.
Mayor?
I will second that, Mr. Chairman.
Okay. Appears we have a motion and a second to deny.
The basis, Mr. Mayor, for the motion is, for the purposes of the record.
The basis of the denial is the fact that we have a 150-foot buffer that our EC recommends that we maintain over the DEP's regulation. The fact that the downstream analysis is not done and we don't know completely of the engineering that would be in respect to that. And also the fact that there is still some questions as to the water runoff, if it will be actually adequately maintained. So until all those are answered, I do not want to put as a conditional approval. I would like to have that as my condition of denial.
You join in that, Mr. Delcor?
I do. I think the stream corridor issue is a serious one. I think we've had our professionals talk about that. I think we've had tremendous input from a number of folks that understand the issue here, and I think there's just still too many questions. As the mayor noted, I think we recognize that we were looking to see what could be done here, but I think the application does not meet what we should be doing and matches our requirements here locally. So I concur, or I'll second the mayor's motion.
Does
anyone wish to be heard on the motion? I would indicate for the record, Mr. Chairman, that both you, Mr. Hestag, has reviewed the transcripts and or video and or tapes of prior hearings that he was not at. He viewed the videos on the 21st of January and on the 4th of February, and he is an eligible voter for this evening, as well as all the other members of the board here this evening.
Okay, thank you. So, Mr. Bernstein, at this point, we have a motion for denial. Do we need to take a vote on that, or?
Yes, you do. I would point out to the board that a yes is a denial and a no is against the motion.
Okay. Are there any other motions that I can entertain at this point, Mr. Bernstein, or do we need to take a vote?
There is another motion that wishes to be, but at this point, I think the motion before the board is a motion to deny.
Okay. So with that, I'm just gonna give one more opportunity for any board members to comment. Okay. So,
Yeah, I would. Yeah, I'd like to thank the board, the professionals, the public, and understand that, yes, as a property owner, you have a right to do with that property what is allowed by zoning and ordinance. So for the 27 attendees, understand that you own property, you do have rights to do with that property what's allowed with reasonable waivers. So, with that, I'll kick it back to the chairman.
Okay, thank you.
I would indicate for the board's edification, this is an inclusionary development application. And with that, there are certain obligations that the board has, that the township has entered into, and there will be an impact, the amount yet to be determined if the board were to vote in favor of the resolution.
Thank you. Any final questions on, before I open up for roll call, that everyone understands what a yes vote represents and what a no vote represents? Okay. So with the silence, I am going to request a roll call, please, on the motion on the floor.
Mr. Emick,
Emick, yes.
Mr. Ciccarelli,
Ciccarelli, yes.
Mr. Peason,
Peace and yes to deny.
Mr. Santa Ramita,
Santa Ramita, yes.
Mr. Hashtag,
Hashtag yes.
Deputy Mayor Delcor.
I wanted to just quickly thank the public again for their steadfastness and their input and their passion around this. We wanted the opportunity, as we told you, as the mayor noted, let you come back when the application was heard. And I want to thank you for your professionalism, for your respect, and bringing your matters to the floor. And with that, I'll vote yes.
Mayor Lapani.
Thank you to, again, everybody involved. I'm sure we'll all see you again down the road, but again, thank you, and yes.
Vice Chair Julian
Yes to deny.
and Chair Sirachi.
I too just want to comment, just to thank for everyone for their participation multiple nights. This is probably one of the longer applications that we've had, and seeing in the audience that we have 27 members of the public there. By far, again, thank you for your participation in this process, and for those that have provided commentary over the last few evenings that we've had, have had this application. So with that, my vote is yes.
Thank you, Mr. Chairman. The motion passes.
Okay.
With that, Mr. Chairman, I believe that there is no other business on the agenda. There is an application or one or more next week before this board. And since there is no other action to be taken, I believe the motion is the motion to adjourn.
Okay, so just before we do that, just again, remind everyone, we do have a meeting next week. Please let the planning office know if you're unable to participate, to ensure that we do have a quorum for next Thursday evening. So with that, I will entertain a motion of adjournment.
Thank you. Thank you, Mr. Chairman. Mr. Bernstein, will we receive a copy of the draft resolution?
The process, and you have not been through this, Mr. Policastro, before. We will draft a resolution. We will send it to Mr. Maskey for his review. Once Mr. Maskey reviews it and gives it his approval, you will get it. The board will not see it until all the parties have agreed to the provisions. So yes, the short answer to your question is yes.
Thank you, Mr. Bernstein.
Okay. So motion for adjournment, please.
So moved.
So moved. Hashtag.
Second.
Okay. All in favor?
Aye.
Aye. Okay, we are adjourned. Good night, everyone, and we'll see at least the board members next Thursday evening.
Good
Thank you.
evening.
Thank you.
Bob, enjoy